here live to take your U.S. immigration related questions. I also have a good question to answer today, and that is, my employer is threatening to get me deported. Can an employer do this? My short answer is no. If an employer is doing that while you're working with them, maybe you've even stopped working for them, and they are saying things like this, like, if you leave, you're going to get deported. They may not even be saying, I'm going to get you deported. They may be saying, if you leave, ICE is going to pick you up. Or they may be going as far as to saying they're going to call ICE to get you deported. That they may be telling you that they have the power to do that. What I would say in this case is they're not supposed to be doing this. And if they're doing this, then this is likely because they're using this threat to keep you hostage, either to keep you working for them or to keep you fearful so that you can continue to work within their control, or to continue to be subjected to whatever they're subjecting you to. So if anybody is saying, I'm going to call ICE on you, I'm going to get you deported, especially an employer, there's something wrong here, and they are violating you as an individual. You should seek legal advice and assistance to be able to get relief. So, what kind of relief can you get in this situation where an employer or an ex employer is now threatening to get you deported? Because another thing is, if you leave an employer, say you didn't like the work conditions that you were where you were working, or the working conditions, and you left. And now the employer is calling you, they're texting you, they're sending messages through other people telling you that, watch out, because I'm going to get you deported, or I'm going to report the fact that you left. I'm going to report you for leaving. So watch out. If you're in a situation like this could very well be a labor trafficking situation or a reportable labor violation, and you can get immigration relief if you're in a situation like that. So you can always give me a call, schedule an appointment, and we can talk about how to approach it. Should you qualify for immigration relief in the case that you have been threatened by an employer like this, or they're trying to keep you working, or they're trying to get you back to be with them in this situation, then you could apply for what's called T status. That allows you to get immigration relief that then enable you to stay here for 4 years, to be able to gain a path to permanent residence. So after you're approved for this relief, you are able to then go ahead and apply for permanent residence in the United States. But while you're on the 4 year status, T status, you're able to get your work permit as well as your social security number. And this is a valuable form of relief because, in addition to all of that, your family members, whether their family members are outside of the United States or in the United States, they also can get relief as well. And they get it with you. So it's not a matter of, oh, they had to go through this to be able to qualify for relief along with you, just by virtue of being your spouse, being your parent if you're under 21, being your sibling if that sibling is under 18 and you're under 21, being your son or daughter who's under 21 and unmarried. They can also get status here. If they're outside of the United States, they get what's called a T visa to enter the United States. And then once you're all here together, there is a way to then apply for permanent residence. So it doesn't stop at just temporary relief, but you then gain permanent residence and a path to citizenship, because once you become a permanent resident, it means that you have a shot at becoming a U.S. citizen. So this is a form of relief that not a lot of people know about, and sometimes even attorneys don't screen for this. I do screen for this, meaning when I speak with you in a consultation, I evaluate all the forms of relief and benefits that you qualify for, including this. And clients have contacted me. I've represented clients who felt like they didn't have relatives here. They were in situations where they were mistreated or they were currently being mistreated by an employer, and they were able to then get this status, which helped them to gain a work permit, and now they have a path to permanent residence. So this is available as a form of relief. And in addition to this, it doesn't even have to get to the point where you are being trafficked or you're in a labor trafficking situation. If you have experienced or witnessed labor violations, there is also a path to get deferred action. While the Department of Labor, for example, if you've reported this to the Department of Labor, or you would like to pursue wages, or you would like to report these violations, there is then a way to gain deferred action. Deferred action would allow you to get up 2 years here, where you'd be able to get your work permit at the same time while the Department of Labor then looks into your issue. But those are now forms of relief that are now available. T status is something that is an underused form of immigration relief, that it's sad that a lot of people go through this and they're not able, or they're not knowledgeable enough to go and apply for this relief. And I am there to guide my clients through the entire process. I do even not only guide my clients through it, but I guide them through the other aspects of being the victim of labor trafficking. If they need assistance, if they need other assistance while they wait, I do refer my clients to individual case managers that are able to assist them to get certain social benefits should they need those benefits, to be able to sustain themselves while they wait for this relief. So it is one of those areas that I want you to know about. Know that it's available for you. We do have to evaluate whether you qualify. And then once we do determine you qualify, I get started right away and I have your back the entire way through. All right. So, in a nutshell, the answer is if anybody is threatening to get you deported, especially an employer, just know that they cannot be doing that and that you can seek immigration relief. I can evaluate that fact. Now, in another breath, nobody is supposed to be doing that to you to gain control of you, right? And so, this is an employer is one thing, but say it's somebody who is maybe even an intimate partner. You may be married, you may not be married, and they're saying things like this: if you leave me, I'm going to get you deported. This could also be a trafficking situation where, when if you feel like they're doing this to keep you in your place, keep control of you, this is also a type of labor trafficking or sex trafficking situation. You don't have to be kidnapped or tied somewhere, tied up in a basement somewhere to be in a sex trafficking situation. Yes, the trafficker could very well be your intimate partner turned abuser that is keeping you in this position. So nobody should be threatening to get you deported. If you have an acquaintance, a stranger, a loved one, an employer who's doing this to you, seek legal advice and protection. And that's what I help my clients with. All right, so now I'm going to go to questions. Go ahead and put your questions in the comments. I'm scrolling through right now. I'm keeping an eye on YouTube as well as Instagram. And I'm going to go ahead and answer. So bear with me. Hi, good afternoon, Miss Ali. It's nice to see you. Um, Thank you so much. So, Cinco Seek says, keep up the good work. I will. Thanks so much for taking the time to join me today. How can a maternal grandmother get her grandchildren to the US? So there is no direct path to for a grandmother to then sponsor her grandchildren. There are ways through possible adoption, but it's going the how you're going to approach the hi there, Denroy. Have a beautiful day as well. um, Now, how you're going to approach adopt possible adoption is going to be dependent on whether the country. So there is what's called a certain convention called the Hague Convention that some countries are belong to it, some countries don't, and so the rules are going to be different depending on whether they belong to this convention or not. Another thing is that are the grandchildren in the United States or are they not? How old are they? How old are they? What is their age? No, if they are, here's another form of relief though. If those grandchildren are in the United States and they are under 21, there is what's called the SIJS. And if the parents are not in the picture, then that means that they are able to get status here and then permanent residence on their own as long as they're under 18. And in order to get under 18, because what happens is in some, and it depends on some states, for example, in Minnesota, they do allow individuals who are under 21 to apply for this SIJS designation in the court. But once it, and usually with the designation, there's a guardian that's assigned by the court. Then once that is done, it goes to immigration. And as long as that application is submitted before the child turns 21, that means that they are able to then get special status. Sometimes the wait is long for the actual permanent resident, but what is happening now is that they just released, policy information instructions now, stating that those children can gain a work permit and social security number, deferred action, basically. So basically, a status that allows you to be protected from deportation or any kind of immigration enforcement. They can gain that while they wait for their permanent residence. And while they gain that deferred action, they're able to get their work permit as well as their work permit as well as their social security number. So it's as you can see, there's so many paths that the children can take or the grandmother can take, just depending on the circumstances. And this is why I require the consultation, because these solutions, while I do assist my clients to achieve them, they're really dependent on those questions that I asked previously. Age, where are they? What country are they from if they're in the other country? What are the circumstances under which the grandmother needs to get the children to the US? So I have an aunt whose husband is in the process of filing for her, but she's now in the US. She was an RN here. Can she do the equivalency exam to practice nurses in the US while her spouse is filing for her? So that could be a possibility, because usually now when she's doing the examination, she also, in order to be licensed, it's going to depend on the state requirements. So I can't advise on, all the requirements to become licensed as an RN. However, it is a possibility. I've seen where that's possible. But usually some states they require the social security number and maybe evidence that she can work in the United States to be able to complete getting licensed here. But remember that the requirements are different state to state, so it really is going to be the aunt's responsibility So because that's not a legal question per se, that's more related to what she wants, what line of work she wants to pursue, and what the state requirements are. So she needs to check that. Spouse in another country, been married for 3 years, would they get 2 years or the 10 years? So 10 years. So if you have been married for more than 2 years, it's going to be the 10-year permanent residence. I have a question. If a mother is getting married to a US citizen, can her daughter of the age of 33, can she be on the filing? No. So that 33-year-old would not be included in the filing. And I'll tell you another thing, by the way. If that mother married the citizen, and even if that U.S. citizen daughter was under 21, she would not be able to be on the filing. No children can be on the filing of, or no children, nobody, but children specifically, because a lot of people think that they can include their children on the same paperwork. Children cannot be included in the spouse petition of a U.S. So a U.S. citizen spouse, if a U.S. citizen spouse is petitioning for their immigrant spouse, that immigrant spouse can't include children in the application. And I know you may be like, "What? But they're children. They're underage. I can't leave my children behind." That's right. I really think that there is a big gap in the law here, and I think while they were constructing this law, they forgot about the children in the whole mix. And that turns out to be a disaster, especially when the immigrant parent, doesn't expect this. But usually, in this case, what has to happen, not in your case, because the age of the child, the daughter, is 33. But if the child is under 21, unmarried, and the mother married the US citizen before the child turned 18, then the US citizen could sponsor the child as the step parent of the child, but they have to do it separately in a whole separate process. The other is that the mother would just have to get permanent residence and then sponsor the daughter. Now, as a green card holder, the mother would not be able to sponsor the daughter until wouldn't be able to sponsor the daughter if she's married. If she is unmarried, she'll be able to sponsor her. But keep in mind the process is taking 5 to 7 years. I just got married to my husband, who is a US citizen. He's planning on putting in the I-130 petition for me and my son next month. Do I have to add my married name to my passport before he files? No. So you can go through your entire marriage, you can go through the entire immigration process without the need to change your name. That's it has a nice ring to it, right? But it doesn't mean, to the officer, they could care less. What they want to see is they want to see more evidence, meaningful evidence, more solid evidence that your marriage is real. They could care less whether you change your name or not. Is it true that undocumented persons will have become restricted from flying state to state soon? So it could be a possibility where the individual, because they have what's called the Real ID law, where they're going to have a certain designation on the ID, and they will not accept any other form of like a driver's license to travel, because to travel from state to state, we can all use our driver's license. But now they're changing the driver's license to have a certain designation on it. And if those don't have a designation, then it means that they won't accept it as valid identification. And surely that is going to restrict a lot of undocumented immigrants who don't either can't access that driver's license because your status is going to um, your immigration status is going to play into getting that state ID or that driver's license. Now that is happening in 2025, so they have extended it to 2025. Um, all right. Keep putting those questions in the comments. These are great questions, and I'm here to answer them. So put those questions in the comments. All right. So how much are the filing fees for the green card based marriage? So fees are going up, by the way, so keep that in mind. But with the marriage base, it's going to depend. If it's consular processing, it's 535 or 535 to start. And then there are more fees later on when the petition is approved. If you're in the United States, right, and it also depends, by the way, on do you need a waiver? Are there additional documentation that you need to file? So keep that in mind. You can always check the USCIS for fees, but the starting petition is 535, and then the adjustment of status is 1225. And then if you're applying for a waiver because of maybe a past immigration violation or past arrest, that is an additional amount as well. So it's going to depend on what you need. Hi there, good intent. It's nice to see you. Okay, so the children are in Jamaica and they're under 12, so get a consultation, definitely. Because if they're in Jamaica, then it means that it's going to be a much more complex process and it's going to be dependent on a lot of factors. So go ahead and schedule your consultation. What forms do I need to file for my Ghanaian husband living in Ghana? So I don't really get into the forms here just because that is very specific. And this is not a show to help you to do it yourself. I'm not giving you information to go and do yourself because that creates potential that you could make mistakes. What I would say is that the petition, there are forms in place. Usually the starting form has to be the I-130 petition, but the rest of the forms that you're going to use is going to be dependent on what is going on in your case. What circumstances are there going forward? And that's where the consultation is going to be very important. All right. Keep putting those questions in the comments. In the meantime, while I wait for your questions to come in, I'm going to tell you how to get in touch with me to schedule an appointment. Today, I talked about, the fact that an employer may be threatening to get you deported. They may be sending messages to you. They may be sending messages through, through other people telling you that ICE is looking for you, and that may be putting a lot of fear in you. But what I can tell you today is an employer should not be doing that to you. If that has happened to you in the past, no matter how long ago that happened to you, if it is currently happening to you, I just want you to know that there is immigration relief available for situations like this. Go ahead, you can call, schedule an appointment. Of course, I help with various immigration needs. And so, no matter what your immigration need is, go ahead, call and schedule a consultation so I can evaluate what you qualify for and how to best move forward and then get started right away. You can do that by going to the link in the profile. And then my phone number is also all over all of my videos. So there are so many ways that you can get in touch by phone, and you can schedule your own appointment by clicking on the link in the profile. On YouTube, if you're watching, you will see that my contact information is right on the screen. You can go ahead and give us a call as well there. And the scheduling coordinator will be able to help you. So I'm going to answer this question here. Can an immigration lawyer speed up a sibling petition in Florida? Not usually. So if an immigration attorney is telling you that they can get your case done faster, or usually an ethical immigration attorney is not going to tell you something like that. Usually it's one of those people on the street corner that says, we do immigration, we do taxes, we do everything for you. If someone is telling you that they can get you through the process, through a 14-year process faster, run, because that is not the case. You will be unpleasantly surprised. Now, there are few situations. This is going to be rare circumstances. Where there is an urgent need, there is a humanitarian need, and in that case, with Congressperson's assistance, with ombudsman's assistance at the USCIS, with an expedite request, maybe. With permission from the embassy, maybe. But that they apply that very sparingly, and that is very rare to get a 14-year process done within a short period of time, like a year. It's not going to happen. It's going to be very rare. So if someone is promising you that they can get your process done faster, run. Now, what I usually tell my clients is that I'm not necessarily going to be able to get your process done, in the blink of an eye. But by having me as their attorney, I'm able to get them through a smoother process and therefore a faster process because I'm there as their attorney. I can go through the process with my eyes closed, and I'm able to advocate for them and put forth an application that gives the USCIS and the officers the ability to review it. They have everything available to make a decision without asking for more information, without delaying the decision, without doing further investigation, because I prepare a thorough, solid application. So that's where an attorney can get your process through faster. But in regards to processing times and getting past the processing times and, pulling some strings to get your 14-year process done in a year, it's not going to happen. All right, so that's going to be it for me. Thanks so much for your questions. I really appreciate it. I am here available at your service to assist you through your immigration needs. So go ahead, give a call, schedule an appointment, and we can talk. In the meantime, go ahead, think about the questions that you have to ask. I will answer them tomorrow. All right, I see one more and I can't resist. Can you live in one state and file your green card in a next state? So this is exactly why I can represent my clients in all 50 states and around the globe. Because when you're filing the permanent residence, the petitions, it's not, I live in Florida, so I'm going to file in Florida. The starting address to file your permanent residence is going to always be, not always be, but there's a one designated spot, and you may not live in the same state as that one designated spot. So while your process is gonna end in the state where you live, meaning you are gonna attend the interview there, or the field office is gonna release the decision, the local field office in your state, the petitioning process doesn't necessarily start in the same state where you live. And so, as an immigration attorney, this is, uh, I represent clients at USCIS field offices all over the country because it's a national practice where we have to be working with the USCIS offices, immigration courts. We have to work with US embassies all over the country. So we're not limited by state lines or borders. So that's another thing. No matter where you live, I can assist you. Does death of a grandparent qualify for an expedited request of the travel document? Yeah, so it may. It may if the death, it's gonna be on a case by case basis. Say you would like to attend the funeral, and you would like the travel document expedited. That is one way that you're able to request it. Ultimately, it is their decision, but that death could be a basis to expedite a travel document. All right. Thanks so much for your time. I'll see you tomorrow. Bye bye.